Well, recently, more and more often we can see certain conflicts on the borders between the states, where groups of migrants, legal or illegal, try to enter forcibly the territories of the other states. And those states struggle with this problem because they try to find a solution how to protect their boundary, even when their groups are aggressive, and the possibilities to fight with such groups are to a certain extent limited, because it is not possible always to protect all the border, taking into consideration the limited number of soldiers. For instance, now we have such a problem on the border between Poland and Belarus, where the illegal migrants try to enter the Polish territory, and it is very difficult to protect the border between the states. However, nowadays the technological development enables to maybe use those new technologies in order to protect the boundaries between the states. And this is the problem of my speech today. Because I would like to invite you to make a thought experiment and imagine such an autonomous weapon system protecting the boundary. This is something that is maybe out of range of our technological possibilities today. However, I would like to invite you to imagine the most possible, the best possible developed autonomous weapon system. And let us imagine a system that is based on artificial intelligence, that is based on machine learning technology algorithm, that has possible, that is perfectly adjusted to the needs of protecting the boundary. I mean, it is able to detect threats and also to recognize people and whether they are aggressive or not, whether they have weapon or not, and whether their conduct is legal or not. Let us imagine such a system is based on millions of photos, and generally it is very, very efficient. Let's give it maybe 99.99% of efficiency, taking into consideration the detection of threats and reacting to that. And let's also imagine that such a system is able to use different ways of means. For instance, starting from simple preventive ones like speakers saying that, okay, you're acting illegally and stop. If you don't stop, we will do something more. And it can reach, it can use these preventive means until something really severe happens. And finally, it can also use a lethal weapon like regular lethal armor. And let's imagine that such an efficient system is deployed on the border between the states. And in my paper, I would like to discuss whether such a system would be compatible nowadays with the international law from different points of view. Therefore, I will try to discuss the compatibility of such a system with the United Nations Charter, which is to a certain extent a constitution of the public order, international public order, and whether such a system would be compatible with this regulation. Secondly, I would like to discuss its compatibility with the international human rights law, assuming that... Yes?
Some troubles, please continue.
Okay. So in the second part, I would like to discuss the compatibility with such a system, with the international human rights law. And lastly, I would like to also invite you to look at this from the point of view of the international humanitarian law. The difference between international human rights law and international humanitarian law is that international human rights law is applicable generally. However, international humanitarian law is applicable only during an armed conflict. So we will see firstly whether such a such a system is compatible with international law during the peacetime, and afterwards whether it is compatible with the international law during the armed conflict. And starting with the first part, the United Nations Charter provides Article 2.4, which says that all members to the United Nations organization shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. So here we have the general prohibition of the use of force, but also of the threat of use of force, which should be taken into account as an important factor. Moreover, the inconsistency with the purposes of the United Nations should also be taken into account while discussing the compatibility with the international law of the conduct of particular states. So what is the threat of use of force? Because that is something that seems quite compelling when we look at those autonomous weapon systems. So here I want to provide you with some excerpt of the jurisprudence of the International Court of Justice that tried to interpret the notion of the threat of use of force. So here we have ICJ's view on that point, for instance, from its Corfu Channel case, where the ICJ indicated that Article 2.4 should be interpreted widely, because the alleged right of intervention as the manifestation of a policy of force has given before rise to most serious abuses, and such cannot find a place in international law. And also in the case of nuclear weapons, the ICJ indicated that threat of use of force is unlawful when the envisaged use of force is contrary to the purposes of the United Nations or principles of necessity or proportionality. So here we should look at what those purposes of the United Nations are. And one of them is to maintain international peace and security, and to that end, to take effective collective measures for prevention and removal of threats to the peace. However, here, when we have the autonomous weapon systems placed on the border, maybe it is difficult to maintain those purposes alive. Moreover, what also ICJ indicated in the Nicaragua case, in that case, the armed ships floating outside of territorial waters of a state and not even entering them were recognized as a threat of use of force. So there is no need to deploy the weapon to use it so that it becomes a threat of use of force. So now let's look at this, at the autonomous weapon systems from this point of view. When we have those autonomous weapon systems deployed on the border between the states, there is a constant risk, maybe a threat of force, because those weapon systems are equipped with lethal weapon. And it is always possible to use this lethal weapon on the territory of the other state. Moreover, there is no human control, so there is no control of anyone over the risk, no risk management, which also should be taken into account. And is such an instrument, which is really an instrument of war rather than of peace, is it compatible or rather contrary to the principles of the United Nations, to the purposes, which is maintaining of the peace? This is to a certain extent doubtful. Okay, moving on to the second part, which is discussing the compatibility of the autonomous weapon systems with the international human rights law. Firstly, let's look at Article 6.1 of the International Covenant on Civil and Political Rights, which is generally accepted as a norm of customary international law. Every human being has the inherent right to life. This right shall be protected by law, and no one shall be arbitrarily deprived of his life. And we should particularly look at the last sentence of this article, which is no one shall be arbitrarily deprived of his life. And now let's try to interpret this notion of arbitrariness. And the Human Rights Committee has discussed that multiple times. It indicated that the notion of arbitrariness is not to be fully equated with against the law, but must be interpreted more broadly to include elements of inappropriateness, injustice, lack of predictability, and due process of law, as well as of reasonableness, necessity, and proportionality. I would like to concentrate the most on the notions of due process of law and reasonableness. Moreover, the Human Rights Committee indicated that the obligation of state parties to protect and ensure the right to life extends to reasonably foreseeable threats and life-threatening situations that can result in loss of life. Therefore, state parties may be in violation of Article 6, even if such threat and situations do not result in loss of life. So even if there is no person that was killed, but only if there is a threat of arbitrary deprivation of life, this article is violated. Moreover, one of the members of the Human Rights Committee indicated that Article 6, paragraph 2 of the Covenant authorized capital punishment only for the most serious crimes, and attempts to cross a frontier, even illegally, could in no case be considered a most serious crime. Therefore, the killing of a person in such circumstances would be simply a summary execution without trial, practice that is unjustifiable under Article 6. Moreover, the draft convention on certain conventional weapons indicated that human judgment is essential in order to ensure that the potential use of force systems based on emerging technologies in the area of lethal autonomous weapon systems is in compliance with the international law. So the human judgment is essential here. And now let's look whether our autonomous weapon system, that is the most developed one that we can imagine, whether it's compatible with human rights law or not. So we have the notion of arbitrariness, which should involve so lack of arbitrariness should involve the due process of law and existence of reasonableness in taking human's life. However, here in our thought experiment, the autonomous weapon system there is no human control over this system. So neither of the above premises is fulfilled, because there is no due process of law, because the killing of a person is automatic, and also no reasonableness, because the machine works based on an algorithm and not on a certain reasonable judgment. Moreover, what we can see, it is not important that a person is killed by such a system to take into consideration the violation of the human rights law, because the violation is there even if there is only a threat of arbitrary deprivation of life. And moreover, what is important here is the existence of human judgment, which is essential to render such a deprivation of life compatible with the international law, because the machine is able to do only the quantitative decisions and not qualitative judgments, which are necessary in such a case. And now let's look at this point from the third point of view, which is international humanitarian law. I will remind you that we take it into consideration only in the situation when there is an armed conflict. So normally during an armed conflict, the rules concerning possibility of use of force or use of weapon are lower than during the peace. However, let's see whether also during the armed conflict the autonomous weapon systems are compatible with international humanitarian law. Article 1.2 of Protocol 1 to Geneva Conventions says that in cases not covered by this protocol or by other international agreements, civilians and combatants remain under the protection and authority of the principles of international law, derived from established custom, from the principles of humanity, and from the dictates of public conscience. This article is generally known as Martin's Clause. This provision says that that weapons that are not regulated by the protocol, and generally that are not regulated in the international humanitarian law, and as long as they're contrary to the public conscience, they're incompatible with international humanitarian law. It's a general clause that enables to delegalize weapons that nobody expected them to emerge. However, they were developed, and finally they should be considered incompatible with the international humanitarian law. And in the International Court of Justice in the nuclear weapons case also used the Martin's Clause and affirmed its importance, saying that the Martin's Clause, whose continuing existence and applicability is not to be doubted, it indicated that it had proved to be an effective means of addressing rapid evolution of military technology. So taking into consideration the autonomous weapon systems and their compatibility with the international law, we should take into consideration their compatibility with the Martin's Clause, because there is no international agreement on the applicability of the autonomous weapon systems. Therefore, Martin's Clause is applicable here. Autonomous lethal weapon system deployed on the border between the states can in fact cause dread or fear to the civilians, because there is no person that can make a human qualitative judgment whether to kill someone or not, and because it is all devoted to a machine and to an algorithm. Therefore, it can cause certain fear to the civilians, and to a certain extent, this can be contrary to the public conscience. And I will remind you that in our thought experiment, such a system is based on machine learning system, and there is no certainty what are the results of such a machine learning algorithm. It can start from being really efficient, but finally it can end up with killing anyone approaching the border. Therefore, this can significantly be contrary to the dictate of the public conscience. And to conclude, in my opinion, the autonomous lethal weapon systems protecting the borders are incompatible with the international law, particularly with the UN Charter, because they constitute a threat of use of force, with the international human rights law, because they constitute a threat of arbitrary deprivation of life, and finally, with the international humanitarian law, as deployment of such weapon could be contrary to the dictates of the public conscience. Thank you for your attention.